everyone. My name is Fabia Fernandes Carvalho. I teach international law at FGV São Paulo Law School. I'm here with Professor Pål Wrange from Stockholm University, who is with us this week to teach a short-term course, Cybersecurity and International Law, as part of the school's Global Law program. Pål Wrange is a professor of international law at Stockholm University and the director of the Stockholm Center for International Law and Justice. His research has concerned military force, the structure and practice of the international legal order, and most recently, the governance and use of cyberspace, with particular attention to the role of the economy. So, Pål, it's a pleasure to have you here with us, and especially for me, as we met a few years ago in Melbourne, so it's great to see you in my side of the world.
Thank you.
Great. I'm genuinely happy. So I wanted to start by inviting you to tell us a bit more of your, as I understood, it's your most recent project connecting issues of international law to the discussions related to digitalization and the cyberspace. Of course, I had the chance to read a little bit about it, but if you could share with us the ways in which you think issues with digitalization are somehow renewing familiar debates for international lawyers.
Yes. Well, I mean, digitalization, computerization, networking, all of these things have been going on for a couple of decades or more. So it's not really that new, but states have still to really figure out how these fairly new still phenomena fit into the established categories of international law. And that relates to fundamental concepts like sovereignty, territory, intervention. It also relates to slightly more specific issues, like, for instance, what is a good or a product under international trade law, or what is a civilian object. Can a data set, for instance, constitute an object under international humanitarian law in the sense of the Geneva Conventions and additional protocols? So there are still things that states need to figure out. And of course, when I mean states, I mean there are lots of people who have figured out for themselves, so to speak, or for their organizations, or for their some governments that have a clear view about this. But states together have not done this yet, and it's partly, I think, because there are, conceptual difficulties about how to fit something unfamiliar to the concepts that were developed for the familiar world, the
toolbox of international law?
In real life world, okay. so to speak. So, and of course, the concepts are abstract, territory, sovereignty, and so forth. But we know basically how they apply, in the kinetic or physical or real world, so to speak. But it's more difficult to figure out how they apply when it comes to digital phenomena. So that's one part of the problem. The other one is, of course, the geopolitical, geoeconomic, and so forth circumstances. So states have widely different interests, and the mood is not so good for settling very difficult issues. And in the meantime, states have developed practices. They practice according to a certain view of whether data or software can constitute a good or not, and they have practices, regarding their own, which fit with their own view of territorial sovereignty. So, for instance, regarding cyber espionage and things like that. So,
I see. So, in a way, the project aims at mapping this state practice and also in a way, try to, and this is something I found really interesting. It actually brings to the surface issues that were always there in international law, even if it's somehow a new kind of challenge to international law, this digitalization and the digital era, or whatever we should call it, but in a way bringing old challenges in terms of jurisdiction and how far a state can interfere in the affairs of another state. So the project aims at offering us a mapping of current state practice. Would this be a good outcome of the project? As you say that new laws for this problem might not be something feasible in the near future, or?
Yeah. So, well, new laws. Many states think that we do not need new laws. That's actually one bone of contention. Or whether the existing principles and rules already are applicable. But we certainly need more clarity. I think that everyone can agree on that. Now, so the project is not really about sort of mapping the details of the practice, but rather how states have conceptualized these things. How they think about, say, what does it mean to cross a border in the digital world, or what does it mean to exercise power? What does enforcement mean, for instance? So it's about how they translate or how they apply those fairly abstract concepts to a new reality. So that's one part of it. The other one is that in these discussions, states have been forced to sort of go back to basics, to think about what is sovereignty really, what is territorial sovereignty, and what is jurisdiction, what does it mean, and so forth. And in that process, so many states are issuing position papers. So my home state, Sweden, has done that, Brazil has done that, many others. So where they set out their views on these issues. And then they have to sort of explain, this is what we mean by state sovereignty in general, and this is what we mean by state sovereignty for information and communications technologies or cyberspace. So I use the term cyberspace with quotation box because I don't think it's a very good term for legal analysis.
I see.
It's a good term for other purposes, but not for legal analysis, because I don't think that cyberspace is a new space that is unregulated. It's just people and stuff, basically. Okay, so when they then, explain what they mean by sovereignty, by intervention, and so forth, and then in the next step they explain how they think that all of this applies to the digital world or cyberspace. Yeah. Well, I think it's fair to say, but I haven't really been able to look into this deeply yet, but I think it's fair to say that some people are actually, or some states are actually de facto changing established meanings of these terms. So territorial sovereignty, what it means to violate territorial sovereignty, for instance, seems to be a lot less strict in the digital environment than it does in real terms.
So this brings me to another question that I wanted to invite you to share your thoughts with us. So you're looking at both conceptual problems in international law and also the interests and the way states have been somehow put forward certain conceptual perspectives for these new challenges according to their interests and geopolitical perspectives. But you are proceeding with the project as a lawyer, as an international lawyer. So what's if you could just tell us more of how you put in this, in your own picture, issues of politics and law, how this geopolitical issues that you've been studying, and of course it has a huge connection to the conceptualization of cyberspace and what you can do. As an international lawyer, what's your take on putting together these interests and international law and law in politics more broadly.
Okay, so I worked for 14 years as a legal advisor at the Minister for Foreign Affairs. So I have I would say I have an intuitive feeling for or an intuitive sense for when there's politics going on, so to speak. Yeah. But I've also always studied international law from that perspective. But I do think that international law is a discourse of its own. It's not the same thing as politics in that sense. You talk law in a different manner than you talk politics. Obviously, you can also say that law is politics in the sense that you use law to achieve certain purposes, and you even invent new concepts or new doctrines in order to fit with political interests. So that's my approach. I look at these things as a lawyer would, I analyze them as legal concepts and as legal arguments. But I also note when a legal argument seems to be very convenient for a particular type of interest. But I'm not trying to sort of trace that. It's not process tracing in that sense. But even though I think in some cases it's fairly clear that there is some form of interest going on behind the presentation of a new particular doctrine that fits a particular interest of a particular power very well.
So great. And this also takes me to another question. Now, the countries, the states that you have been looking at, mainly states in the global north, and then let's say some kind of BRICS kind of states. You mentioned Brazil as well, that I'm sure has a very strong take on non-intervention as a main pillar to our position. So this relates to both your experience here teaching, as I learned from you, your first time in South America, right? So teaching these issues in Global South, I would love to hear from your experience so far, but also in your assessment of all these governmental positions and the documents that you have been, the statements that you have been studying. How do you see the role of countries that might probably suffer the consequences of a certain interpretation in the global north regarding the interference of how you can hack the data or softwares, whereas maybe countries in the global south might not have the proper conditions and possibilities of even conceptualizing their practice. So how does this play in your research project first, so the countries that you're looking at, and then it would be great to hear from your experience in teaching people in the Global South. You don't have students that are all from the Global South. It's a diverse cohort, but it would be great also to hear from your week of teaching with us.
Okay, thank you. Well, first of all, the Global South is everywhere and the Global North is everywhere. There's a bit of Global South in Sweden as well. And I think Brazil is,
we are probably in the Global North of Brazil, right? I'm sure.
Yeah,
yes.
Well, I mean, Brazil is definitely a mix of Global South and Global North. And I think, having said that, I think that even countries that you would 100% associate with the Global North, like Sweden, for instance, or the US and so forth, they're mixed interests. So much of the discussion is driven by the national security establishment for historical reasons, but also because they have there's more at stake for them. They have a more interest in moving the discussion forward in certain directions. But I think that in Sweden or the United States or as well, there are other societal groups or branches of government that have different interests. So I think that one must note that there are different interests in all states. And so regarding the Global South, so I spent 3 years in Uganda in Africa, and I taught there at 2 universities. So I actually have much more teaching experience in Africa than in South America. And I think teaching here was, not that different from teaching in Stockholm.
In Stockholm?
In Stockholm.
Okay.
Yeah. So there were some students who I thought definitely took sort of a Brazilian position, but I also think that so I don't know what the Brazilian position is, except that I, of course, read the position paper, which I think is very good, and I agree with much of it. But I think that there are probably different interests also in Brazil, and I think some of them, I would guess that some parts of the Brazilian national security agencies, share some of the views of, say, the British or American national security agencies, whereas I'm sure there are civil society organizations or industry organizations and so forth that have different interests in Brazil, in Uganda, or the US or Sweden.
Okay, great. So if I may, one last question. I understand that you are in the making in terms of your project related to the cyberspace and international law. How would you describe the main outcome of the project? What kind of, is it something that will trigger new discussions about maybe new policies? Is it something that you aim to, interfere in the public debate? Or, as you said, it's more about the conceptual articulations that we see by different states about classic issues of international law. So it's more of a theoretical or conceptual intervention in this theme that is so alive and kicking, in our lives nowadays.
Well, I don't have any policy proposals. So I certainly, I'm a bit schizophrenic in the sense that so my approach is to just analyze. But of course, I'm also a doctrinal lawyer. I have my own taste, so to speak. I like some arguments better than others, and there's some arguments proposed by some governments that I strongly disagree with.
Of course.
Even though I sort of can see the logic of those arguments. But again, law is not logic in a mathematical or philosophical sense. It's a different kind of logic. It's about connecting arguments to one another. And it's, in a sense, about developing a taste for what is a good argument or not. Now, so the purpose of my research, or the way I hope it will be used, is that it will sort of deepen the understanding of the issues and perhaps, look a bit further into the arguments, perhaps to take fewer things for granted.
Sure.
Yeah. So I think that's the purpose. So it's critical in that sense that I want to go a little bit deeper than some of my academic colleagues have so far.
Okay, so Paul, thank you very much for this conversation. I too share the critical sensibility in international law, so I always love to ask these questions because I think it helps us and other people who actually are wanting to put forward the debate and go deeper in the argumentative practice that international law is. So to hear this articulate answers, I think it's very productive for us working under this similar sensibility. So thank you very much. I hope you have been enjoying your time here
very
in São
so.
Paulo. And it was great to see you again. And I hope we can meet.
My pleasure, absolutely.
Yes, again, in other corners of the world.
Yeah.
Thank you, Paul.
Thank you.